Welcome back to SCOTUS Oral Arguments and Opinions. I'm your host, and today we're diving into 6 major Supreme Court decisions from June 20th, 2025. These cases touched on nuanced issues such as FDA tobacco regulation, criminal sentencing guidelines, administrative law, judicial review, workplace discrimination, and even international terrorism. Let's walk through each case, examining not just what the court decided, but how the justices reasoned their way to these conclusions. Let's start with FDA versus R.J. Reynolds Vapor Company, case number 23-1187. This case involved R.J. Reynolds, the tobacco company, and in this case, R.J. Reynolds applied to market its e-cigarette products. The FDA denied the application, finding that R.J. Reynolds failed to demonstrate the products would be, quote, appropriate for the protection of public health, end quote, under the Tobacco Control Act. Here's the wrinkle. Reynolds could have challenged this denial in the D.C. Circuit or the Fourth Circuit, where the company operates. Instead, Reynolds joined with Texas and Mississippi tobacco retailers to file in the Fifth Circuit, where the retailers conducted their business and sold and intended to sell the R.J. Reynolds products. The question in this case was whether a manufacturer may file a petition for review in a circuit where it neither resides nor has its principal place of business if the petition is joined by a seller of the manufacturer's products located within that circuit. The question somewhat told the answer here, and in a 7-2 decision, the Supreme Court permitted R.J. Reynolds to join and file their claim with the Texas and Mississippi tobacco retailers. Justice Barrett wrote the majority opinion. She was joined by Chief Justice Roberts and Justices Thomas, Alito, Kagan, Gorsuch, and Kavanaugh. Justice Jackson wrote a dissenting opinion, and she was joined by Justice Sotomayor. As far as the majority opinion, the court applied a broad interpretation of who can be, quote, adversely affected under the Tobacco Control Act. The majority found that the retailers face significant direct impacts, including lost profits and potential criminal penalties if they sell unauthorized products. Under that rationale, they were considered to be adversely affected, and as such, persons who could bring a claim relating to the denial of a petition. Justice Jackson's dissent focused on statutory interpretation. She argued that the majority largely ignored context and essentially nullified the zone of interest test. She contended that Congress established a detailed scheme for manufacturers to obtain authorization within which retailers have no rights and play no role. Justice Jackson also emphasized that Congress provided a cause of action for protecting manufacturers' statutorily created interests, not retailers' economic interests. This reflects a narrower view of who Congress intended to protect under the regulatory scheme. Next up is Fold v. Palestine Liberation Organization, case number 24-20. This case emerges from the ongoing conflict in the Middle East and Congress's efforts to provide remedies for terrorism victims. The case involves 2 consolidated lawsuits filed under the Anti-Terrorism Act of 1990, which creates federal damages actions for U.S. nationals injured or killed by international terrorism. The defendants are the Palestinian Liberation Organization and Palestinian Authority, entities that carry out governmental functions for parts of the West Bank and Gaza Strip. Congress passed the Promoting Security and Justice for Victims of Terrorism Act in 2019. This law specifically names the PLO and the Palestinian Authority and provides that they shall be deemed to have consented to personal jurisdiction in terrorism cases under two circumstances. First, in situations where the practice of paying salaries to terrorists in Israel prisons and to families of deceased terrorists. Second, in situations where jurisdiction ties the activities, where the jurisdiction ties to activities on U.S. soil. The question here was whether the Promoting Security and Justice for Victims of Terrorism Act violates the Fifth Amendment's Due Process Clause. Personal jurisdiction requires sufficient contacts between the defendant and the forum state. The Second Circuit held that Congress could not, consistent with constitutional due process, establish personal jurisdiction over the PLO or the Palestinian Authority. In a 7-2 decision, the Supreme Court went the other way and overturned the Second Circuit decision. Chief Justice Roberts wrote the 7-2 majority opinion. He was joined by Justices Alito, Sotomayor, Kagan, Kavanaugh, Barrett, and Jackson. Justice Thomas and Justice Gorsuch joined as to Part 2, with Justice Thomas writing a concurrence. The majority held that the Act's personal jurisdiction provision does not violate the Fifth Amendment because the statute reasonably ties jurisdiction to conduct involving the United States and implicating sensitive foreign policy matters within the political branch's prerogative. The majority emphasized that courts must have personal jurisdiction before resolving cases, but Congress holds broad authority in foreign affairs matters. The court found the jurisdictional predicates sufficiently connected to U.S. interests and conduct. Justice Thomas's concurrence took on a historical approach. He argued that the historical evidence from the framing provides the proper framework for deciding these cases. He concluded that the Due Process Clause places no territorial limitation on Congress's ability to call parties to answer in cases involving foreign affairs. Justice Thomas emphasized that the Act meets the standard requiring deprivations to accord with settled usages and modes of proceeding existing at common law. This reflects a textualist and historical approach that focused heavily on the original meaning rather than modern policy considerations. The third case is Diamond Alternative Energy, LLC v. EPA, case number 24-7. This case involves the intersection of environmental regulation and automotive policy. Under the Clean Air Act, the EPA approved California regulations that required automakers to manufacture more electric vehicles and fewer gasoline-powered vehicles in the state of California. Several fuel producers sued the EPA and argued the agency lacked authority to approve California's regulations because they target global climate change rather than local California air quality problems, as the Clean Air Act requires. The D.C. Circuit held that the fuel producers lacked Article 3 standing. They found that the fuel producers failed to establish that automakers would likely respond to invalidation by producing fewer electric vehicles and more gasoline-powered vehicles. California intervened to defend EPA's approval, arguing that automobile manufacturers would not change course given, quote, surging consumer demand, end quote, for electric vehicles, regardless of regulatory requirements. In a 7-2 vote, the Supreme Court held that fuel producers have article standing to challenge EPA's approval of California regulations. Justice Kavanaugh wrote the majority opinion. and he was joined by Chief Justice Roberts and Justices Thomas, Alito, Kagan, Gorsuch, and Barrett. Justice Sotomayor and Justice Jackson filed separate dissenting opinions. According to the majority, the regulations can have coercive effects on third parties sufficient to establish redressability for standing purposes. California's own estimates show substantial reductions in gasoline demand beginning in 2020 and increasing in significant amounts over the next 10 years. Justice Jackson wrote a sharp dissent. What stood out most prominently was her that how unusually pointed it was. Justice Jackson argued that the court shelves its usual case selection standards to revive a fuel industry lawsuit that all agree will soon be moot. Justice Jackson criticized the majority for applying a theory of standing that the court has refused to apply in cases brought by less powerful plaintiffs. She argued that this decision gives fodder to the unfortunate perception that moneyed interests enjoy an easier road to relief in this court than ordinary citizens. Justice Jackson also noted that one core component of California's emissions program, the electric vehicle mandate, will soon terminate when 2025 ends. She questioned why the court even granted review in a case that will soon be moot anyways. Let's turn now to McLaughlin Chiropractic Associates, Inc. v. McKesson Corp., case number 23-1226. This case involves the intersection of telecommunications and administrative law. The Telephone Consumer Protection Act protects businesses and consumers from intrusive telemarketing by prohibiting unsolicited fax advertisements to telephone facsimile machines without opt-out notices. McKesson sent unsolicited fax advertisements through a subsidiary in 2009 and 2010 to medical practices, including McLaughlin Chiropractic Associates. McLaughlin sued for damages and sought to represent a class of fax recipients. While McLaughlin's lawsuit was pending, the Federal Communications Commission issued the Amerifactors order interpreting telephone facsimile machine in the TCPA to exclude online fax services. This interpretation potentially affected many class members who received faxes through online services rather than traditional machines. The question in this act was whether federal law required the district court to accept the FCC's legal interpretation of the Telephone Consumer Protection Act. Specifically, the Hobbs Act, which provides that FCC final orders are reviewable exclusively in courts of appeals, not district courts. In a 6-3 decision authored by Justice Kavanaugh, the Supreme Court held that the Hobbs Act required the district court to accept the FCC's interpretation, even though this interpretation significantly affected the pending class action. The majority opinion was joined by Chief Justice Roberts, Justices Thomas, Alito, Gorsuch, and Barrett. Justice Kagan wrote a dissent, and this dissent was joined by Justices Sotomayor and Jackson. The majority reasoned that the Hobbs Act creates exclusive jurisdiction in courts of appeals for reviewing FCC final orders. District courts cannot collaterally attack these interpretations even when they affect ongoing litigation. Following Ninth Circuit precedent, the district court correctly deemed the Amerifactors order binding and granted summary judgment to McKesson on claims involving online fax services. What stood out in Justice Kagan's dissent is her concern about the practical effects on private litigants. The FCC's interpretation, issued months after class certification, effectively gutted the class by excluding online fax recipients. Justice Kagan argued that requiring district courts to accept FCC interpretations without review creates unfairness when these interpretations emerge during pending litigation. This concern reflects a tension between administrative efficiency and private litigation rights. The dissent would have allowed district courts more flexibility in handling FCC interpretations that significantly affect ongoing cases. All right. The fifth case is Stanley v. City of Stanford, case number 23-997. This case involves disability rights and employment benefits. When Karen Stanley worked as a firefighter for the City of Sanford, Florida, starting in 1999. When she was hired, the city offered health insurance until age 65 for two categories of retirees: those with 25 years of service and those who retired earlier due to disability. In 2003, the city changed its policy. It continued providing health insurance for those up to age 65 for retirees with 25 years of service. But for those retiring due to disability, it would provide just 24 months of coverage. Stanley later developed a disability that forced her to retire in 2018, entitling her to only 24 months of health insurance under the revised policy. The question here was, under the Americans with Disabilities Act, does a former employee who was qualified to perform her job and who earned post-employment benefits while employed lose her right to sue over discrimination with respect to those benefits solely because she no longer has her job? This was a complex voting outcome. The Supreme Court held that to prevail under the ADA, a plaintiff must plead and prove that she held or desired a job and could perform its essential functions with or without reasonable accommodation at the time of the employer's alleged act of disability-based discrimination. There's a majority on parts 1 and 2, and that involved Justice Gorsuch writing the majority opinion. In it, he was joined by Chief Justice Roberts, as well as Justices Thomas, Alito, Kavanaugh, Kagan, and Barrett. As for part 3, there's a plurality, and that involved Justice Gorsuch, who wrote it, as well as Justices Alito, Sotomayor, and Kagan. Justice Thomas wrote a partially concurring opinion, and that was joined by Justice Barrett. And Justice Sotomayor wrote a partially concurring, partially dissenting opinion. Justice Jackson wrote a dissenting opinion, and that opinion was joined by Justice Sotomayor as to parts 3 and 4. The majority of the court emphasized that the ADA requires plaintiffs to be, quote, qualified individuals at the time of discrimination. Since Stanley's complaint alleged discrimination that occurred after retirement, her claim failed. Justice Thomas, as I mentioned, wrote a notable concurrence, and in this concurrence, he took aim at the increasingly common practice of litigants urging this court to grant cert to resolve one question and then pivoting entirely to a different question afterwards. Justice Thomas argued that this bait-and-switch approach undermines the court's case selection process and wastes judicial resources. This has been a common critique of multiple justices throughout this term and even last term. Justice Jackson, in her dissent, focused on the factual allegations. She argued that Stanley's complaint contained sufficient facts to draw a plausible inference that she worked with a disability and was thus subject to the discriminatory policy sometime before retiring. Justice Jackson criticized the plurality for failing to accept Stanley's factual allegations and draw reasonable inferences in Stanley's favor, as required at the motion to dismiss stage. Justice Jackson also emphasized protecting disabled individuals with limited resources. She noted the case involves a disabled firefighter suffering from Parkinson's who has consistently maintained that the city's change discriminated against disabled beneficiaries. Now turning to the last case, Esteras v. United States, case number 23-7483. Our final case for today involved federal sentencing law and supervised release. Esteras pleaded guilty to conspiring to distribute heroin. The district court sentenced him to 12 months in prison, followed by a term of 6 years supervised release. While on supervised release, Esteras was arrested and charged with domestic violence and other crimes. The district court revoked Esteras' supervised release and ordered 24 months of re-imprisonment. The question was, even though Congress excluded certain factors to consider when revoking supervised release, may a district court rely on these excluded factors when revoking supervised release? This involves technical but important distinctions in federal sentencing law. Section 3553A sets forth 10 factors courts must consider when imposing sentences. Section 3553A2A covers retribution, the need for the sentence imposed to reflect the seriousness of the offense, to promote respect for the law, and to promote just punishment for the offense. The question was whether even though Congress excluded these 10 factors, may a district court nonetheless rely on them when revoking the supervised release, as I mentioned. When Congress addressed supervised release revocation in Section 3583E, it listed 8 of the 10 3553A factors, but it specifically excluded Section 3553A2A and one other factor. The district court explained that Esteras' earlier sentence had been, quote, rather lenient, end quote, and that his revocation sentence must, quote, promote respect for the law, end quote, a consideration from the excluded Section 3553A2A. A 7-2 majority held that a district court considering whether to revoke a defendant's term of supervised release may not consider Section 3553A2A, which covers retribution vis-a-vis the defendant's other underlying criminal offense. Justice Barrett wrote the majority opinion. She was joined by Chief Justice Roberts, as well as Justices Thomas, Kagan, and Kavanaugh, as well as Justices Sotomayor and Jackson, as to all but Part 2B. Justices Sotomayor and Justice Jackson each wrote concurrences. Justice Alito wrote a dissent in which he was joined by Justice Gorsuch. Justice Barrett's majority opinion emphasized that when Congress specifically excludes certain factors, courts cannot ignore that exclusion. The court found Congress's omission was intelligent and meaningful. The majority noted that supervised release serves different purposes than initial sentencing. While initial sentences can include retribution for the underlying offense, supervised release revocation focuses on the violation of the release conditions and future supervision needs. Justice Alito's dissent argued that courts retain inherent authority to consider all relevant factors unless Congress explicitly prohibits such consideration. According to the dissent, Congress's failure to include Section 3553A2A in Section 3583E does not necessarily mean courts cannot consider those factors. They distinguish between mandatory consideration and prohibited consideration. Justice Sotomayor's concurrence, joined by Justice Jackson, agreed with the majority but emphasized limiting the holding to retribution for the underlying offense. Justice Jackson filed a separate concurrence emphasizing similar concerns about the scope of the ruling. All right, those were the 6 cases. I'll have more analysis on them next week. What stood out across the 6 cases to me is how procedural and jurisdictional questions dominated the court's docket at the end of this term. 4 of the 6 cases involved questions of standing, jurisdiction, or procedure rather than pure substantive law. The voting patterns reveal both predictable and surprising coalitions. Justice Jackson emerged as the most vocal critic, filing dissents in 2 cases and raising concerns about the court's priorities and case selection. We also had a rare scenario where Justice Alito and Justice Thomas were on opposite sides of the opinion. And as I mentioned, that was the Asteris case, where Justice Alito authored the dissent, and Justice Thomas, however, was a part of the majority. That concludes our analysis of the 6 opinions from June 20th, 2025. Thank you for listening to SCOTUS Oral Arguments and Opinions. Until next time, this has been your comprehensive analysis of the court's latest decisions. Talk to you soon.